Kinsella Funerals was once one of the biggest and most prominent funeral directors in Sydney. They were innovative. For instance, they were the first funeral directors to use motorised hearses in Sydney. It was a family company with Kinsella family members occupying all of the significant leadership positions. A common way of paying for funerals is by way of a funeral fund. You make regular contributions while you're alive, and in return, your funeral is all sorted once you die. Nowadays, these are regulated as financial services. Once, though, they were simply business schemes operated by individual funeral providers. Kinsella Funerals had a funeral fund, and it was in trouble. The contribution rate did not take sufficient account of inflation, which had been historically high in the 1970s. They had many funeral obligations and little income. They were running at a loss. New legislation had just been passed to regulate funeral funds, and this was about to expose their financial difficulties. When you took into account the future liabilities for providing all those prepaid funerals, the company was technically insolvent. Running scared, they made some financial moves, including the company leasing the main premises to two Kinsella family members and directors at well below market rates. The company went into liquidation, and the liquidator challenged that lease. Now, companies can make decisions which benefit directors provided there is full disclosure, and there was. But how is this situation affected by the company being so close to insolvency? Chief Justice Street said, "It is legally and logically acceptable to recognise that where directors are involved in a breach of their duty to the company affecting the interests of shareholders, then shareholders can either authorise that breach in prospect or ratify it in retrospect. Where, however, the interests at risk are those of creditors, I see no reason in law or in logic to recognise that the shareholders can authorise the breach. Once it is accepted that the director's duty to a company as a whole extends in an insolvency context to not prejudicing the interests of creditors, the shareholders do not have the power or authority to absolve the directors from that breach." The lease was reversed. From this case, we learn that when a company is close to insolvency, the directors have a duty to consider the interests of the company's creditors and not just its shareholders.